Okay, it is halfway through summer. We're gearing up for a new school year coming up, guys. And I'm in sort of my relaxed, tone. I don't have any meetings today. I'm still working, but we didn't have any meetings, so I'm not going to sit there and get all gussied up for you guys. But this is something that I wanted to sort of discuss. I think in some states it's far worse than others with regards to what I'm going to discuss, which I completely understand, depending on the state, why parents file due process complaints or state complaints with the assistance of an advocate or without an advocate. I totally get that. Um, at the same time, if what we're seeing, for example, in Texas, and this is a huge problem that we're seeing in Texas, is that we're seeing far too many parents filing complaints and then immediately trying to hand those complaints post filing to my office to then jump into and take over. And I can't stress enough, don't do that. Don't do that. Please, for the love of little baby Moses, don't do that. Stop doing it. And this is the reason, guys. The even though it's a minimal standard to file a due process complaint, meaning that there's not a lot that has to go into it to be accepted as valid with regards to a due process complaint, it triggers a timeline. You get a hearing officer assigned. They have to have a resolution meeting within the first 15 days. Or the school district can waive resolution, which the resolution meeting's on the school system. It's not on the parent. The parent doesn't have an automatic right to a resolution meeting. That's what the complaint's for. Okay? The resolution meeting requirement is on the school system. They have to have one. But if they don't, then they'll request waiving the resolution meeting, which of course the parent has to agree to. But they'll waive the resolution in order to go to mediation. Okay? Now that's a compliance thing. Now a school system can sit there and say, hell with it. We don't want to have a resolution meeting. Now that doesn't look good. And they get a ding on their compliance record for not having a resolution meeting. But at the same time, that's possible. But it starts the timeline. And you have a hearing officer. And so if you do that and trigger this and you start moving forward on the timeline and then you go, oh crap, we need a special education attorney. And you come to my office, guys, Rome wasn't built in a day. We have to develop these things. We have to review everything. We have to sit there and lock this stuff up so that we understand what the substantive issues are, separate those from any potential procedural violations, do an analysis on whether those procedural violations that might exist raise to a level to where it causes harm, educational harm, regression, or stagnation. And if that's the case, then it tips over and we can add that to the substantive violations. There is so much that goes into that, and we try to compress it and we try to do it as quickly as we can. But keep in mind that once again, in order for us to do this right, so that we avoid actually having to go to a hearing and absorb that risk of not achieving the results that we want to achieve for you and your child, it takes it takes some time. Could take 3 weeks. It could take a month for us to work through all of that, depending on the complexity of your case and how and where we are with regards to the lineup of processing these things. But guys, being patient with us is very important because we do it right and we get the results that you need for your child. And so slapping stuff in and slapping stuff together, other attorneys might do that. My office does not do that. But that's also why we have the track record of success that we have, because we do it right, we do the proper analysis, we ask for the records, we try to understand the issues so that we can solve the problems. And we can't solve the problems if we don't understand the issues and if we can't convey the issues to the school district in a way to where they understand what they did wrong. Because guys, once again, I can slap a complaint in 5 minutes if I want to. And the school system, many of them will sit there and say, make Delaney go away. And they'll slap some solutions on there. But I'm telling you, that does not solve the problem. We have to have the school system understand what they did wrong, where the missteps and the mistakes were. The parent needs to understand that so it doesn't happen again. And then understand it to a point to where now we're lacing in the solutions and we're constructing the house. But if you slap in based upon what an advocate's recommending that you do, unless it's an outright emergency to where it's got to be a stay put issue to where you need a marker, you need that in there, then that I understand, but that's a rarity, guys. That's a rarity. And I'll explain, if you, I don't have time on this video to explain the instances of why and when you should assert stay put in order to get that marker in there. But I'm telling you, by and large, don't file due process complaints. And then the other thing is, guys, don't file state complaints. State complaints are different than due process complaints. State complaints are being reviewed by the state education agency. There's no due process hearing officer assigned. There's no court. There's no back and forth of getting testimony. Okay? It is a review done by the State Department of Education based upon what you submit that the school did wrong. Now, state complaints are good if you're making procedural arguments that the school system didn't have the right number of people at a meeting, if they didn't provide a prior written notice. Those are all procedural, like they didn't follow the rules. Okay? That is not the same as declaring that your child didn't receive a FAPE. That's a substantive violation. That is a substantive argument that's reserved for a due process hearing officer to make that ruling. It is not something that a state Department of Education is good at making a determination on. And so if you're filing a lot of state complaints going, oh, Eureka, I'm going to have the State Department. Why in the heck would you ever have Mama Alien make determinations of whether or not Baby Alien provided your child a FAPE? Now, the State Department of Education in your state has a compliance duty under the federal law, but that compliance duty is to audit the local school systems to ensure that they're complying with procedure. Procedure. Not that they're providing a FAPE. That's a completely separate analysis, that they're not trained to sit there and make the determination. And by and large, there's no court. There's no questioning of witnesses. You provide your supporting document, and then they go to the school, they send this off to them in email or in mail, and they say, hey, this person filed a state complaint and talked trash about you, and you have X number of days to respond and provide supporting evidence. They don't go into the school and investigate. This is all done through email or through writing, and then they make a determination. Once again, state complaints deal with the State Department of Education conducting an analysis back and forth of whether the school district complied with procedure. Now, too many parents and too many advocates will use it as a cross utilization to sit there and say they didn't provide my child a FAPE. Well, what's the danger? Well, what if they come back and say, we feel like they provided your child a FAPE. We didn't find that you were correct in your analysis. Well, it doesn't mean that you can't file a due process complaint after your state complaint lost. But guys, it doesn't look very good. And now we're fighting uphill because now you have the State Department of Education involve themselves in something that they had no business involving themselves in, largely because you didn't know. And you had an advocate that also didn't know. This is why we have Advocates University. This is why I have this page, so that we can all get better in our knowledge together and not make these little strategic mistakes. But guys, I'm telling you, filing a due process complaint with a hearing officer, it triggers those timelines. We need time. Because I'm telling you, once you start that, it turns into a legal process. And if you don't understand the legal process, you don't understand the timeline, you don't understand the exchanges, you don't understand the discovery rules, especially in Texas, then I'm telling you, you're going to be spinning your wheels and you're going to freak out, you're going to have anxiety, and you're going to want James to take it over. And I'm going to have to sit there and start telling people, we won't take your case if you already filed a due process complaint. We need that time. Now, is it a done deal? No, of course, guys, because you can withdraw your complaint without prejudice. What I'm saying is you can withdraw it and then bring it to us and we can refile. And there's no harm, no foul. You don't get in trouble for that. So in many instances, that's what we'll do. We'll just say, we'll take it, but you need to withdraw your complaint so we can start over. Because what ends up happening is if we allow that complaint to stay, then what we're doing is we're filing an amended complaint, which then starts the timeline over again. But then at the same time, what it does is it gives a school system an opportunity to sort of convolute the argument and convolute what the issues are. And that's one of their strategies, is to swamp the hearing officer with information. Swamp the hearing officer that everything is fine and dandy. I mean, Texas, already your IEPs are 30 to 60 pages long. It's full of garbage, but the garbage is intentional because it's a misdirect. So you have to know what you're doing to be able to hone in on where the issues are, why they're not good issues, why they fail to provide a FAPE to the child. We need that time to develop that argument. Okay? State complaints are good, but understand when to use state complaints. Due process complaints are necessary, but know when you need the assistance of an expert like myself. And in the states where somebody like me doesn't exist, to where they're charging outrageous retainers, I'm sorry. But in the 4 states, Michigan, New Mexico, Texas, and Alabama, where we do have an office, most of our cases, we take on contingency. Chill. Let us handle it. And believe me, it will be worth it for you.